welcome once again to the Defense Chronicles. This is Leslie Bocobo. Tonight we have with us Dean Jose Roy III. Good evening, Dean Roy. Can you please tell us the implication of the withdrawal of the prosecution for Articles 1, 4, 5, 6, and 8?
Well, there are certain technical implications as well as substantive issues. As we have said from the very beginning, the problem always has been that the complaint is defective, it is weak, and it does not amount to offenses worthy of impeachment. Now, you can see that when this is the case, we end up in a fishing expedition because the complainant tries to muster as much assistance it can from the subpoena process to find any kind of evidence to sustain its charges. Whereas in this case, we have seen the introduction of illegal or fabricated evidence. Now, when a complainant is unable to sustain his charge, the best thing for him to do is to amend the complaint. And in fact, it was pointed out by Senator that whether it be a matter of civil or criminal procedure, the only avenue available here would be the amendment of the complaint with leave of the court. Now, this presents several other interesting problems. Can the complaint be amended by the prosecutors themselves? Because they are not complainants alone. There are 188 complainants, right? And effectively, by transmitting it here, the complaint was adopted by the House of Representatives. So that might necessitate a return to the House of Representatives. We don't know which way the court will rule. The second issue is what is the effect on the case? Well, as far as we're concerned, we would regard this as an acquittal or a termination of those issues against the Chief Justice. And our concern at this time would be to ensure that these grounds are never used again against him. It would be unfair after subjecting him to this process, forcing him to submit to the jurisdiction of the court after he has entered a plea denying those grounds, that they should be allowed to charge him again later on. I think it is material that everybody should take heed about the evils that result from a politically motivated impeachment process. It is clear at this time that this is not about violations of law, but about political agendas, whosever they may be. We don't need to point the finger. But needless to say, the impeachment process today, as we have witnessed it, is traumatic. Traumatic for the system, traumatic for our democracy. It is traumatic for the prosecution, for the defense as well, especially for the Chief Justice. It is traumatic for the Senate, traumatic for the judiciary, traumatic for the people. Now tell me, with a complaint like this, what good has it brought us? And some of those who blindly believe that this is fair, or those who blindly support the politics behind this complaint would say, well, at least it has shown us the weaknesses of the system and the need to refine it, and we have discovered weaknesses in the law. Well, I am sorry, but that is nothing but a crock of rubbish, simply because I can't use a more precise word. You do not need to plunge the nation into something like this to identify weak spots in our system. What we need is to re-examine our consciences and find out once and for all, are we really interested in justice, or is this just politics?
Now, Dean Roy, in effect, the articles are effectively withdrawn. In the very words of the presiding officer, effectively, they are abandoning the 5 articles already. But earlier today, we noticed that a member of the prosecution manifested a motion to invite Justice Sereno to appear?
I think that they've withdrawn that manifestation or that reservation, and the remaining reservation has to do with evidence regarding the bank accounts.
Yes.
But I think for enlightenment, you should know that the defense has filed a motion to suppress evidence.
Yes.
Our position is that the introduction of stolen evidence, the introduction of false and fabricated evidence, or falsified evidence,
Yes.
cannot be permitted. And all the evidence arising out of the use of this falsified information is what we call the fruit of the poisonous tree.
Yes.
And it should not be permitted. Now, the argument presented by the prosecutors is that the fruit of the poisonous tree does not apply, because that applies only when the search is performed by a government agency. And their contention is that here, the information was not given to them by a government agency. But you see, the evidence on record is quite clear. There was an AMLA search conducted.
Yes.
All right? In addition to that, those cases they cite where they say it was not a result of a government search applies to cases of evidence which is not strictly prohibited. This is a different case because the bank accounts, information from bank accounts is strictly prohibited. So even without an illegal search, you could not ordinarily acquire the information regarding bank accounts. And that is why we're saying all of this has to be stricken out. But there is a second issue that must be addressed, and that is whether the Article 2 involves ill-gotten wealth. It does not. Article 2 refers only to the SALN. So this evidence, supposedly being admitted under Article 2, paragraph 2.3, is only being admitted for the purpose of introducing assets which were not included in the SALN. Now, whether or not that constitutes an impeachable offense is the real issue. And as you know, you may have learned by now, that in Republic Act 6713, which deals with the SALN, there is a section 10 which allows for the correction of the SALN. This is why it is difficult to claim that the failure to include assets in the SALN is an impeachable offense.
Earlier over the radio, we heard Senate President Juan Sereno, and he was asked about the articles that the prosecution rejected. He said he was asked why, and he mentioned that hindi kakagat. Does this mean that from the start these articles had no teeth?
In a one-time situation, you could just get it there and then
To be proven worthy in the impeachment court.
Well, as I was saying, Leslie, from the very beginning, I have always maintained that the entire complaint is a sham. I've been challenging anybody from the 188 complainants to come forward and say what they personally know. And we have been asking for that. That was the first thing we asked from the court, was to give us a preliminary hearing so that we could address our preliminary objection. But the court said that they did not want to question the transmittal of the House. Fair enough. Fair enough. But I think the way it has played out proves, in hindsight, proves my point, that there is much left to be desired. If though it is called a verified impeachment complaint, there does not appear to be anything here that is really impeachable.
Can the prosecution file the same article they withdrew next year?
We think not. We think not. As I've said, having subjected the Chief Justice to the process, having forced him to submit to the jurisdiction of the court, and because he's entered the plea of not guilty to all the charges, it would be unfair to charge him again. And I really don't think the Filipino people want to see that. That would be turning political might or political power, turning justice into travesty simply because some individuals wield a bit of political power. That is entirely wrong.
Thank you very much.
Thank you, Leslie.
Thank you
Very nice. See you.
Thank you for joining us once again with the Defense Chronicles. This is Leslie Bocobo.